round of applause to Mr. Tom Franklin.
Thanks, Tom.
We have a relatively small group, and I have a relatively small number of slides. So please interrupt me if you have any questions as I go along. We'll make this more interactive. Here's what I'm going to cover today, and after the presentation I got a stack of slides there. Look at the stack of slides. Here's always where I start out when I talk about our presentations. We're kind of in this interesting time in which we're moving from the industrial ages into the information age and the knowledge economy. And people think about what does that mean, right? So I have some quotes here. Some of them are really kind of old, but I think it's some newer quotes. But if you look at this chart here, this is what I found most fascinating. Is if you were in 1978 and you looked at the market capitalization of a company, you would find that 80% of that market capitalization could be traced back to something, right? They own a building, they might have a set revenue stream, they might have inventory, but at any rate, they were real assets. And 20% couldn't be attributed to anything, so at the time they'd call that goodwill. But if you fast forward to, I would say today, but it's actually 7 years ago, it's been flipped. So if you look at the market capitalization of a company, 80% of it can't be traced back to anything, right? And I think that's what it means to be in this information age, this knowledge economy. Is if you look at a company like Apple, for example, what assets do they have? Beautiful campus, okay? A little bit of inventory in their stores, not very much because it's flipping over all the time, maybe some refurbished product or something like that to sell. They really have almost no assets, and they, I guess, aren't currently the wealthiest company on earth, but they were in recent history. So we're in this time where what they own is that little label on your product that says designed by Apple, right? It's their ability to design fascinating products, right, that enthrall us and that sell very well. But they don't own the factories. They probably don't own the parts inventory. They really don't own very much. So you would find if you look at their market cap, you could probably only trace 1% back to tangible assets, right? So we're in this fascinating time. So in this fascinating time, I think the role of the IP attorney has become more important, because if you look at the wealth that is in the company, 80% of it is stuff that I can help you protect, right? Whereas before, 80% of it was what you would hire security guards or have traditional physical security in place. And that was a whole different animal than what we're doing today. So every enterprise, and as you went through the room, it was fascinating. There was a wide spectrum of different people, from business owners to people that were thinking about it at all different phases. So whenever I talk to a client, there's this amorphous cloud of stuff, right? The word that people use is intellectual capital to describe it. It's all the things that make up your company. And when I put together this chart for a client, actually the most valuable thing they had was business relationships. They were owned by, here in town, by a very well-connected, wealthy individual, and the fact that he was starting up this company meant everything, and that he was in the business and could refer work and stuff like that. Well, that is an intellectual property, but at any rate, it's in this cloud. There were certain things that were in the cloud that we could help protect. They had certain ideas on how to roll out the product. They were building out a strong brand. It's a very strong brand today. In their business, there was lots of things to do with promotions and how to do those successfully. Very little on the manufacturing side, very little. Some software, some business methods, some ideas about the future. But everybody has this cloud. If we went around the room, we could figure out what it was. So what I'll do is I'll sit down with somebody, we'll kind of look at that cloud of things, and we'll figure out what we can do about it, right?
And the tools that I have at my disposal are these kind of traditional tools you've heard of: trade secret protection, copyrights, patents, and trademarks. What they will do is the stuff in the cloud, you can't own an idea, right, in the cloud, but if you write it up as a patent and you file it and you get your patent issued, all of a sudden that's something you can own. You can buy and sell that, right? But if I just stand up here and start telling you about what I'm doing and I'm not filing any patents, you can go and take those ideas from me. So these tools allow you to capture this stuff into property. So the capital becomes property, intellectual property, through a lot of these legal tools. And some of it happens without you doing anything. For example, in the case of a trademark, you just start using your brand and you start to accumulate certain rights in that brand. Copyright is the same way. You can also do copyright filings or trademark filings to enhance that value, right? But what I'll do, I do a lot of speaking at business schools because they really don't teach this. They talk about that 20% at the business schools, when really what today we need to be talking about is that 80%, right? That's what's important today. So anytime I sit down with a new client, well, let me start. It's very expensive to work with an IP attorney. We tend to be twice as expensive as your run-of-the-mill attorney at an hourly rate. So attorneys are expensive. Well, we're twice as expensive as attorneys because you're paying for somebody with a technical background. Me, I'm an electrical engineer. You're paying for an electrical engineer and an attorney at the very same time. So we tend to be very expensive. So really key in this process is to come up with a strategy that works for your business. Because we have a business model too. We get paid by the hour, right? So if I don't set up a great strategy for you, I make more money, right? I'm far too busy for those kind of shenanigans, and I want my clients to be successful. That's why I do this on a daily basis. So what we'll often do is we'll sit down with them and we'll kind of ferret out how you're going to make money. I got in the back of my mind these tools. Sometimes the stuff in the cloud I can put into enhance with one of these tools. Sometimes I can't, right? Sometimes there's just kind of business ways to protect what you do, you know, traditional business ways, underselling the competition, getting your product out there more quickly, things that I really can't help you with from a legal perspective. But we'll sit down and we'll kind of talk that through. We'll talk about where you are in your funding cycle, right? Investors like to see certain things. When are you going to be raising capital? Because if you're raising capital, maybe they want to see some patents at that point. Maybe they want to make sure your business entity is set up right at that point. So we'll talk about that. We'll talk about your exit, right? What's your plan, right? A lot of times when I'm building up a strategy, it's a strategy to get you guys funding because the patents, when they issue, it's the new owner's problem, right? Your problem today is to get funding for your model. And then by the few rounds of funding into it, 5 years into it, you're probably going to be gone anyway because the big investor is going to come in and they're going to hire professionals maybe and get rid of the entrepreneurs in the organization. So sometimes that's the strategy, right? So I say that the last bullet there before I move on, I think more money is lost pursuing the wrong strategy. So I think a lot of people just say, they'll come to me and say, I need a patent. I'll say, wait a minute, stop. Let's talk about your business. Or I need to do this, or I need to do that. And they've heard somewhere that this is important or that is important. And I'm not going to do the work until you convince me that it actually is important. Because you can spend more money going off on a strategy that is not going to add to your bottom line to enhance the value of your enterprise. And the attorney gets paid regardless, right? Because we just look at the clock, right? And we're getting paid. So designing out what is really important, and you can kind of take a shortcut to figuring out what that is because you look at the businesses that are similarly situated to you. And presuming that they've got good advice and they're doing the right thing, you can kind of model yourself after what they're doing. I think that's the very most basic thing to do. If you're in a space that's heavily patented, you probably have to have a big patent portfolio. If it's all about the brand and nobody's really worrying about the patent, maybe it's moving too quickly for the patents to really be helpful. Maybe it's focusing on branding, right? But look at those analogs, those companies you desire to be, those success stories, and model yourself after those success stories, and you're going to be far better off than talking to a vendor and saying, what makes sense for me, right? So here's my fancy graphic. We have this cloud and we have these boxes, and if I can put something from the cloud in the box, I can convert it into property, right? It can be bought, it can be sold, you can get a loan against it. So I'm going to start off, we're just going to talk about some of these real quickly. Please interrupt me if you don't understand, but we're going to talk about the four major forms of intellectual property. Trade secrets. A trade secret is anything that you can keep secret from your competition and gives you advantage in the marketplace. It's a place to start because it's absolutely free. If I can keep it secret and nobody can find it, I don't have to hire an attorney. It can get, at that starting point, it sounds very simple, but it can get kind of complex after that point because you'll say, well, I can keep it secret. Well, are you ever going to ship your product? Because if you're ever going to ship your product, almost anything can be reverse engineered, right? So the prospect that you could keep something trade secret when you're going to be selling it in high volume at the target is just unrealistic. Anything can be reverse engineered today. Any piece of software, any integrated circuit, anything, any chemical compound. It has to be secret, so it can't be in the public domain. So you could have, for example, an employee that takes your stuff and posts it on the internet, or somebody steals the idea and posts it somewhere. It's very hard to put that genie back in the bottle.
So can you give some examples of trade secrets?
Yeah, so Apple has been on the forefront of many of these trade secret issues in that their new product releases, right? I think less so lately. It seems as though people can pretty readily find out about the new products, but they surprised us with the iWatch, right? A little bit. Nobody thought it was going to be introduced then. People surmised that they were working on it. Now what people are doing is they're watching what Apple is filing on their patents, right? Because patents get published after 18 months. But when Apple is introducing that, and what it's going to look like is a huge secret, because everybody knows that that's going to be probably the competition that you're going to be up against.
Let me ask you a question about that, Tom. The patents are published after 18 months, and I know that now tech journalists just spending a lot of energy publishing patents. Is that something that might change, or are there companies that will be able to file a patent that will have a longer privacy period or something?
Yeah, so the comment was, there's this 18-month window and journalists are taking advantage of it. And we'll get to patents, but no, I think there are ways to keep it secret. If you agree to not file it overseas, you can keep it secret until the day that it issues, right? Of course, it has to be known at that point. But overseas, they require publication after 18 months. So if you're filing it overseas, there's no good reason not to keep it from publishing in the US. So most of these companies have big ambitions overseas, so they let it publish. I would say almost all of my clients let their patent applications publish. And there are certain advantages to doing so. You can sue people and get a little bit more damages. There's some incentives to doing so. But that's at the very heart of the patent system, is we're going to make you fully disclose what you're doing in exchange for a limited monopoly. So it goes to the very heart of the issue. And in the US, that was one of the criticisms, is that you could keep your patent from becoming public until the day it issued. And there were some people that kept them patent pending for decades, right? And submarine patents would pop up and people would be, oh my gosh, you have a patent to barcodes and we've been doing it for 30 years. So that was, this push to publication, I think, is a good thing. It shifts that boundary, if you believe in that bargain that was struck where we get full disclosure in exchange for a limited monopoly. So as long as you can keep it secret, it never expires. So one of the examples that people think of is the formula for Coca-Cola. So what I say is that if Coca-Cola had sought a patent on it, Pepsi would taste better today, right? And I shouldn't say that because Pepsi's a client. But at any rate, you get the idea. Is if they had filed a patent, you could publicly get the formula.
And Pepsi being Coca-Cola.
Yeah. So I mean, there's this battle going on today. As a practical matter, if you Google it, there's 15 people on the internet that claim they have the formula Coca-Cola. So it becomes less of an issue in today's world. But back then, certainly, how you made something, it was very difficult to reverse engineer this sort of thing. So that trade secret was very valuable. Today, it's the counterexample. It's that once you start shipping it to people, they can very easily break it down into its chemical components and probably figure out exactly the ingredients that were used to make it. So people.
So Tom, are you saying that trade secrets are less effective today because we're so kind of culturally aware of everything going on?
Yeah. So the question was, are trade secrets less important today? And I would say that's kind of the balance is always changing, right? So it's something you have in your arsenal. I would say where it's most effective today and where I still think it's very valuable is the things that you do internally into your enterprise, right? So if it's a manufacturing process where you look at the end product and you can't determine how they did it, very effective in that regard. And every company has trade secrets. Who are your customers, right? Well, I'm a salesperson working at your enterprise, and I found out somebody else is making a similar product, or I can make the product myself. I'm going to go out and start competing with you. And I know who to call on, right? Well, that's a trade secret, who the sales list is. Maybe who your component suppliers are a trade secret. Who your employees are. I was told at one point, this was before LinkedIn, but a recruiter would pay $500 to get the company directory, right? With the names and titles, because they could start calling people, right? A little less relevant in this LinkedIn age, but everything you wouldn't want people to know. And to the extent that you put safeguards in place to keep it secret, the courts will recognize that. Now, if I toured the Coca-Cola factory and on the wall was a list of ingredients, courts are going to be loath to later let you sue somebody for stealing that formula, because anybody on the factory tour could see it. So you've got to put things in place. And I think maybe it was with Coca-Cola. Someone was saying that only 2 people in the company had access to it, and the formula was in a safe. Maybe it was Colonel Sanders' 13 spices. I don't know what it was. But at any rate, you've got to put safeguards in place, because the courts are not going to jump in if you've been sloppy about it. So like when I worked as an engineer 20 years ago, they had the ability to search my bag, right? And that was all about protecting trade secrets. It becomes a much stickier thing today because you can attach anything to an email, right? So a lot of it has to do with making it clear to your employees and your partners and your vendors what is a trade secret. So people will put proprietary, right, confidential secret on their presentation. And when you're working with the partner, you'll say, hey, you'll negotiate an NDA perhaps, and you'll be very clear about what is trade secret and what is not trade secret. And if you do that very religiously, and something happens, it sneaks out, you find that competitor is developing the same product when you had an NDA in place, you can go to the courts and have them solve those issues. So people will have a trade secret program. When employees leave, they'll remind them, remember that formula that you were working with? That's secret. I know you're going to work for Church's Chicken, but the 13 spices, that's ours, right? Copyrights, and I'm kind of going in order of cost. The trade secret really didn't cost anything other than these procedures in place within your enterprise, right? A non-disclosure agreement, thinking through the issue. Copyrights protect artistic expression in a tangible form. So it's not me speaking, it's not the words flowing to you, because that's not an intangible form, but I copy the slides there. I think we do have a copyright notice on it, I don't care. Copy it all you want. And we're videotaping this, so the videotape, presumably I could put some controls on that. I think it's going to be widely available. But if you wanted to start up a business where you're taking those recordings and reselling them to people, we probably didn't authorize that. We certainly authorized you guys to look at the notes, review the recording, or anybody that has access to the recordings on the site can review it. But don't start up a business called Kilpatrick Patent Training and reselling that. Where it comes in to play quite a bit in my practice, my background is electronics and software, is software as embodied, as it's written out, has been interpreted to be artistic expression. Because you can implement that functionality in any number of ways. But, you know, a coder, it is art. You know, if anybody's done some coding, or anybody's looked at some really bad code that they had to rewrite from somebody else, you'll appreciate that that terminology is spot on. It is artistic. So it comes up a lot, and you can almost think of it as plagiarism, as if you take code that was developed by somebody else and don't have rights to it, and you put it in your code base, you've just given ownership of your code to somebody else, right? So where people are playing with that trade-off or that problem is in the open source area, where there's a bargain that if you use our code and you improve our code, and then if you do certain things like ship it to others, you're required to give away your improvements to that code. And there are all kinds of strategies that my clients are interested in to either get the benefit of open source and perhaps not have the burden of shipping your code to your competitors. But all the time, companies are messing it up. I mean, I think TiVo has an open source model, and they struggled forever because they had some of the best DVR software to not have to ship their code to everybody else. But they got the benefit of getting all this free code to start off with. So they were able to code up their device probably in a fraction of the time. But then when it came to turning over the code, they started getting kind of slippery about it. But that's the bargain that people cut in the open source space, is we're going to help you get a business going very quickly. But as you improve what we've done, you've got to give those improvements back to the community. And the community is pretty good about getting all over the people that are not recognizing that bargain properly. But it had a funny artifact. I mean, I digress for a moment. If you've been in my business for a long time or in electronic software, we've had kind of many attempts, client server, and then we had, you know, software as a service, and now it's called cloud, right? It's all the same difference. It's that you put the computing away from you, and locally you have less computing power. One of the things that open source requires is if you ship your product on a disk to somebody, or you know, you give them a copy of the code, you're then subject to many of these open source requirements. But if you use it internally, you are not, right? So this whole rush to cloud computing that's happened has been because companies like proprietary, and this is a way to use open source without giving people a copy of your code base. So my theory is that this recent move to cloud computing has been motivated by this desire to get the benefits of open source without the burden of having to share your code. It's very difficult to have a business model where anybody can ask for a copy of your software and compete effectively. It's a very tough business model. You've got to keep moving. You've got to keep adding new features. You can never rest on your laurels. And so a lot of companies will sit there and decide whether they want to go proprietary or they want to go open source. If they can have everything in the cloud, they can pretty effectively have something that they can not have to share with others and still get the benefit of open source. Question?
The frustration with that is that some of us have spent decades trying to get away from that mainframe-centric model with timeshare terminals, ASR 33s and stuff using that timeshare computer. And we made this incredible revolution to get a personal computer in everybody's hands, and now in their phones, and now they're seeding all that back to the central mainframes.
And it's because of the open source movement. So the lament was that way back when with the mainframe servers, you had all this sharing, processing, sharing time and stuff like that. And we're back there again. And it's flipped back and forth. I mean, I graduated 35 years ago from engineering school, and yeah, about then. And I've seen it flip 2 or 3 times in that time period. The flip today is because of open source. Because here's the thing, is if I am building up a company, what am I doing? I'm accumulating wealth and property, intellectual property, in an enterprise and I'm doing it to the benefit of my shareholders, or I'm probably shareholders to the benefit of me too, right? That's what companies do, and it's really hard to have a business model where you're giving stuff away. And that's always been the problem with open source. There's an anti-patent movement out there, same sort of thing. If you want companies to be incented to solve big problems, and once they solve these big problems, you have to let them make a buck or two off of it. Because if I can't get a patent on something, and software patents has been a major setback, it's very difficult to get software patents today in some areas. Well, people aren't going to invest in solving these big problems, because that was the bargain, is you solve this big problem, you spend the money on R&D, tell us how you did it. After 18 months, I can find out what the brightest minds in any company were doing. After 18 months, let me know what it is, and maybe I'll design something different or better. And the bargain is we'll let you make money off that invention for a little while, so you can keep that lead that you had. And the fast follower model is not more effective. Because if everybody adopts a fast follower model where I just see what's successful and I copy it, no one will invest in solving big ideas. And that's kind of the dichotomy you have going through all these things. And I sit there on the side of capitalism and saying, look, you're coming to me because you're trying to accumulate wealth. I get that. This is not a socialist model. You're truly trying to be rewarded for your effort, and I'll help you do that, right? So copyrights are lovely when it comes to software or anything like that. Anybody that's stupid enough to copy somebody's stuff will get in trouble. The rights are very strong. I'm not even sure. It might even be that copyrights go on longer than that. It seems as though copyrights go on for as long as Disney needs them to go on for. So they've had several extensions that have come through. Today you cannot take those scratchy Mickey Mouse cartoons from like 1905. You cannot take those and start up a business model to sell them, right? You're not investing in my business model to sell those. There's no value in those cartoons today. Yet you could not take those cartoons and resell them because they keep extending the life of copyrights. And people think that's somewhat controversial, because the bargain is we'll let you, if you create some sort of piece of art, we'll let you in your lifetime make some money off of it. Maybe one generation after that, your heirs, maybe a company over a period of time. But really, and then at some point it goes into the public domain. Well, the amount of stuff that goes out into the public domain is almost zero, right? Because I can't even start up that business model I want with those old scratchy cartoons. So trademarks. Here's where, like a copyright, you got protection just by creating it, right? You can register your copyright, but there was no need to register your copyright. The registration gives you certain enhanced rights. It's very inexpensive. I think the fee, the Library of Congress administers the registration. It's like $50. It's a form. I think I filed these 3 times in my career for clients that just totally don't want to deal with it. We'll charge them $500 when we go about doing it. There's a couple of tricks to filing them. Generally what I say to people is once your thing gets out in the wild, seek a registration. So you get to 1.0, you're shipping your software, someone might knock it off. File for your copyright registration, but maybe not for the 1.1 or the 1.2, but the 2.0, yeah, a lot of chances. Go ahead and register it again. Trademarks. A trademark is anything that is used as a source indicator. So people think of course, your company name. Every company has a trademark. So one of the little bits of trivia is if you look at, and we haven't gotten through the whole list, but if you look at the value of all the different types of IP, what's the most valuable? And some people will say, oh, patents. Patents are where it's at, right? And we're going to talk a lot more about patents today than we are anything else. But really, it's trademarks. Every company has a trademark. In the strip mall, there's 15 of them, right? It's that name out there. And by using that name, they're accumulating what we call common law rights. But they're kind of those rights that you get without registration. And you'll get local rights so that I can't start up a training center right next door. I know there's open space, and I'm going to call it DaVinci Club. Not Institute, Club, right? And we're not going to have boot camps, we're going to have shoe camps, right? You can't do that sort of thing, right? It protects you, at least in this particular area, in the footprint of what DaVinci Institute is doing, or what's, I don't know who else is in this, alfalfas. I can't start up a market called alfalfas here in town, but I might be able to in a state that doesn't have an alfalfas. I grew up in Southern California, and there's Kroger's is called Ralph's out there, right? So if you go into Ralph's, you can use your Kroger card, right? A little tip for you. But at any rate, in San Diego, there was a little corner store, Ralph's Corner Groceries or Bodega or something like that. So when they came into town, old Ralphie raised his hand and said, wait a minute, you know, people are going to confuse me with you, right? Which was a little ridiculous. But at any rate, when I was growing up, it was called Lucky. It was a Lucky supermarket. And at some point, they bought out old Ralph in this corner store because they're now called Ralph's. But I could probably start up a Ralph's here in town, maybe, because there wouldn't be any common law rights because of the footprint of Ralph's in Southern California. They're called King Supers out here and City Market, right? But except if they've gone to the trouble of filing for a federal federal trademark registration. A federal trademark registration will give you rights in all 50 states. So it's very common if you've got a business that's operating in multiple states to go and pursue the federal trademark registration.
How do you resolve that when you get a federal trademark and then there's already a legacy companies out
Yeah.
in this country at the state level?
So the question is you pursue your federal registration, what about all the other people out there? So we'll often do a search to find out what the topology is, so you're not having to buy off old Ralphie in his little market, right? And we'll find out what that topology is, and you'll search on, certainly Google it. But old Ralphie would have been 16 pages into the Google search, right? It would have been pretty hard to find. We'll look at the Secretary of State's records to see if they've filed for a fictitious business name. Some states have their own trademark registrar where you can file. But your question was more specifically to who has superior rights with regard to that. So the first person to use has rights to the scope of their use. So old Ralphie had probably not even all of San Diego. He just had that little part of San Diego that would frequent his bodega. But maybe he was right on a freeway off-ramp, right? And you had all the people driving back and forth. So people will look at that and they'll look to see if there would be confusion, right? If you're driving down the freeway and you see a Ralph's grocery store and 14 exits up, you see Ralphie's Corner Bodega, you're probably going to think it's the same company, maybe. I don't know. But therein lies the argument. So when you get that federal trademark registration, it basically lays your stake down as of that date, and you get what they call constructive use. You're not using it in that state, but we'll say that you are using it in that state. So it's not uncommon to do a federal registration. You're using it in a couple states. You do a federal registration. You lock down your dates in all the states. But there's going to be a couple states where you're going to have issues, right? And you have to go state by state solving those issues, maybe buying people out. It's always a confluence of not only the services that you're offering, but the name. Of course the name, right? But if I had been Ralphie's shoe repair, right? I mean, Ralph's doesn't do shoe repairs. They maybe sell flip-flops. I don't know. Maybe there's an argument there. But you kind of come into that. It's always how close are the goods and services that you're selling and how close is the name. And it's a confluence of those two things that you've got to think about. So you can have, people of exactly the same name. So long as they're selling wildly different things, there's really no issue. So there'd be no customer confusion. But generally, the way that I think of it for entrepreneurs is that if you've come up with a name because you're riding on somebody's coattails, you've got a problem. So I had somebody come to me and they had a social networking thing and it was something book. It wasn't Facebook, it's something book. I'm like, well, why would you choose book? Well, we're choosing book because, It's just like, look, you're riding on somebody's coattails, you've probably got a problem. Dave.
Yeah, how does parody and satire come in? Because in Santa Cruz,
Yeah.
And it was a vegan restaurant that was playing off the McDonald's menu. And then McDonald's sued them and they had to actually change their name. But I think their position was always it was a satirical name. And my understanding is, you know, you get into things like Saturday Night Live and stuff, and there are some changes in what you can and can't touch with trademark.
Yeah, so there's always exceptions to these general rules, right? And certainly in the copyright area, satire is one. Competitive advertising, I can say, I sell better food than Ralph does. You can always be factual about it. You can say, I'm better than this person, right? How could you make that statement if you can't name that person, right? They can't stop you from using the name. So there are exceptions to many of these rules. And Dave brings up the scenario that a restaurant chose a name that was a satire of another restaurant. And from the trademark perspective, if you're using a name that's similar to someone else, satire doesn't pull it off if you're making money off of the very similar product that they're selling. So if you're doing something commercial on satire, it doesn't really work. It works for Saturday Night Live. That's a copyright issue as you're sitting there. And I guess trademark issues too, but clearly you're not selling the same product as McDonald's when you're doing a spoof on McDonald's, right? But if I'm doing a spoof on McDonald's to sell my stuff, yeah, you got a problem. And one of the cases we've been involved in, and people are still trying to figure out where these dividing lines are. Starbucks was suing Charbucks, right? And we've been involved in that case, and I don't know exactly where it is right now, but it's been rattling through the courts for some time. But clearly they're trading off the name. It's kind of a joke. People think that Starbucks beans are over-roasted. It's probably not a good business model. I mean, where do you go from there? How do you come out with your next product, right? Okay, I get the joke, right? But it really pisses off these big companies. And if it's a big company, regardless of where the rights lie, you're going to probably be spending a lot of money in legal fees. And sometimes that ain't a great model. It's a great model for me. I love those people. If that's your model, come to me. But it isn't a good model for you.
It's kind of a daunting.
So we'll get to that. I mean, we got. So the question is what do you do about these big companies that can kind of bury you? They can use these same legal principles against you. So if you look, I have this line where I say, in my bio, I say, I help large companies maintain their dominance, but I also help small companies who are vying to dominate. And how the large companies use these tools is to keep down the ankle biters. You know, a lot of, as we went around the room, there's ankle biters in the rooms, but largely the entrepreneurial community is filled with people that the large companies would call, the entrenched incumbents would call ankle biters, right? You're an irritant. Maybe I'm going to buy you, maybe I'm going to put you out of business, maybe I'm just going to sell my product cheaper than yours and you'll wither on the vine, right? You'll see that a lot. And you'll have large companies have inroads into politics that small companies don't have, right? The thing, though, contrary to that and what the small companies have is you have nimbleness and agility, right? And it's a battle, right? The big company is trying to hold on to what they've got, and you see it in every industry. And then you have the disruptive technology. But you have nimbleness. And you guys work harder. I mean, geez, you're sitting here on a Saturday. Some people even dressed up. I mean, I kind of had to, but, you know, come on. Those guys, they're playing golf today. They had an early tee time. You know, that's what you have as an asset. And it terrifies them. You are their worst nightmare, right? They wake up in the middle of the night in cold sweats thinking of so-and-so who has this product and might get funding. And you'll see it all over, like Tesla. I watch that. I'm big into electric cars. And, you know, the local dealer, they don't have a local dealer model, so they're lobbying all these state legislatures to make direct sales to consumers on automobiles illegal. Michigan just made it illegal, which is crazy. Who would care, right? It doesn't seem very competitive. Why not have all these ideas competing, all these different business models? So you'll see people manipulate the politics. You'll see them, especially when it comes to patents. Less so in these other areas, unless you make a mistake. You're riding on somebody's coattails. Yeah, if you're successful, the hammer is going to fall on you, right? So that's where kind of thinking about this earlier, and anybody in the room, I have to eat lunch every day. I'm happy to have you come down to our offices for lunch. I'll even buy lunch, and we'll talk about your business model a little bit, and I'll give you my thoughts. We don't charge for that. I would much rather have you start off in the right direction, even if we wouldn't represent you as a client, so you're not one of these cautionary tales, right? I want everybody... Corporate roadkill. You know, call it whatever you want, but I mean, honestly, that's just how the world works. And a lot of these things, like that stuff in that cloud, if you do not use one of these tools to enhance its value or protect it, it is not stealing when I take it. You may think it's amoral. It is not amoral. It is not illegal. So so-and-so stole my idea. What, did you file a patent on it? No. Well, you know, it wasn't your idea. It was still in the cloud. We got to take it from the cloud. We got to protect it. We got to make it so it can be owned by you, right? If that's what makes sense for your business model. Sometimes it does, sometimes it doesn't. My business model is I get paid by the hour, so you got to watch me, right? As if I'm not giving you a good strategy, I make more money, right? That's where the money is. That and clients with crazy things, Charbucks. Copy somebody's name, that's what I'm saying. People will initially, and everybody should be doing this, put a TM after your business name and your products. And that just says, I'm claiming whatever rights I have, if any, in this name. And then if you should go through and get the federal registration, you would use the circle R in those places that you had the registration. So you'd use the circle R when you're shipping in the US if you have a US registration, trademark registration. But if you're shipping in Canada, no, maybe not, right? It gets kind of complex pretty quick. Okay, so who invented the light bulb? This is a quiz. I mean, I know it's early in the morning. This is a quiz. Who invented the light bulb?
Wasn't it?
This isn't a trick question. Who invented the light bulb? Come on, guys. You're thinking too much.
Thomas Edison.
Thomas Edison invented the light bulb, right? Don't take my thunder. So what, and that's my point, is what did he actually do? So the basic structure of the light bulb was known 25 years earlier. I think it was a Frenchman that knew that if you had two electrodes, you put something in between it, it heated it up and it gave off waste. It gave off waste heat and waste light, right, in this process. Edison had a little bit of a problem. He was trying to sell his electricity. I think he had electrified Niagara Falls, if I have that right. So he had all this electricity. No one wants to buy it. He actually had a carnival sideshow where he would go and he would electrocute an elephant to show the power of electricity. I mean, this is entrepreneur carnival Barker. I mean, you know, I mean, he was almost a circus performer, more so than he was an entrepreneur.
Tesla actually was the one that got the contract for Niagara Falls.
Oh, it was Tesla that had Niagara Falls. Okay, so Edison...
He the elephant because to prove how dangerous alternating current was.
Yeah, so DC current, he had DC current, and Tesla had AC current, which was, of course, much more effective. But at any rate, what Edison was trying to do is he was trying to sell this electricity to electrify the downtowns of small towns. And the competing technology was the oil lamp. And the oil lamp, you go around with your little watering can once a week and you fill up the oil. And that was the competing technology. Light bulbs at the time lasted 1 week. How are you going to displace the entrenched technology when you're just as good as it? In fact, you're worse. You've got to run a wire in between all of these things, right? But somebody's got to still go through and change out these bulbs, right? And it's a scary new technology. So he had that problem, and that was the necessity that created his invention, which was he sat there with 1,400 things that could be a filament, and he tried them in succession, right? A monkey can do that, right? I think. Anybody in this room can certainly do that.
That's why he was no genius. It was actually 6,000.
It was 6,000.
He did not do it intelligently.
It was not intelligent. He tried like a horse's hair. It's like, look, who hasn't singed their hair? I mean, come on, guy. You know? But he found out that carbonized bamboo or something like that lasted 6 weeks. That's what he did. Somebody else figured out that if you took the atmosphere out of the light bulb, it lasted 6 months. Who's that person? We don't know. The difference between, and why we say Thomas Edison invented the light bulb, except for some of the smart asses in this room, is because he also invented the movie projector, and they made a movie about it. So A little bit of the, a little piece of the innovation or the story, and a good publicist is what will get you in the history books too, right? So patents, and we're going to spend most of the rest of our talk talking about patents. So it gives you the right to exclude others from doing what you invented for 20 years. And the exchange is an exchange for full disclosure of how you did it. You have to tell people how to make and use your invention. And that's a big deal, because before this point, we had a system where everybody relied on trade secrets. The first industrial age was based on this, as you came up with a better way to make something, and then you just locked it up. You built a company town out in the forest, right, with employees that couldn't even leave the campus, right? They had to have their families out there. There was no kind of cross-pollination. No one was ever going to leave and start up their own factory. So you could keep something secret forever. So in a way, the patent system was an innovation that's in our Constitution that where the government encourages collaboration, if you think about it, right? You tell everybody about your idea, and they can improve on it. They'll come out with the light bulb that lasts 6 months. But we'll let you protect the six-week light bulb for that 20-year period. So in a way, everybody talks about collaboration being the big thing, and patents are against collaboration. I have clients that are going back to trade secret. They're like, forget about it. I got 6 customers. I'm going to put little seals on every device that I send to them. I'm going to lock them up with agreements. And I'm going back to trade secrets, because trade secrets are forever. So in the software realm, I already have clients that are doing that. If they're low volume, if they're not consumer, they're just saying, forget about it. This patent thing, we give up. We're going to go back to trade secrets. We have these algorithms that nobody can figure out, and we're going to be able to get far more value out of that than trying perhaps unsuccessfully to get a patent in that area. People will ask what can be patented, and this is changing all the time. The bane of my existence has been this Alice decision that came out before summer. But at any rate, the famous quote from the Supreme Court is, anything under the sun made by man, except for certain things, right? And that list of exceptions keeps getting larger, and they keep tweaking with that. Because there's this bargain, right? There's full disclosure balanced against a monopoly, and it goes back and forth. People say, well, I really want to do this. Well, I want to do what they're doing, right? I want to make money in the way that they're doing it. Well, look, you couldn't even have had your business model unless you could have stood on the shoulders of those giants. So I get it, you're crying today that you can't have the latest feature. Well, why don't you invest in R&D and you come out with that feature that your customers want? Because that's what the system is trying to encourage, is you invest to solve those big problems, and we'll let you make a couple bucks off of it. But the balance keeps going back and forth on that. So some people will get confused. They say, because I have a patent on it, I ought to be able to do it. No. Because you have a patent on it just means that guy can't do it. It's a negative right. So I'll give an example, it's somewhat silly, but say I invent the automobile, right? Tom's Automobiles, this is, imagine me in a caveman outfit. I've got my automobile and Fred Flintstone guys running around, and it has these stone wheels like they had on Fred Flintstone. Well, the stone wheels, they last 4 blocks because the wheels just chip apart. Nobody's buying my automobiles, but I have a patent on it and I can stop anybody from doing it. Well, somebody down the street invents the rubber tire, right? And all of a sudden, that rubber tire on my automobiles, and you can have what is a practical invention. I can stop him from making automobiles, and he can stop me from putting rubber tires on anything. So what happens in a rational market is you'll have cross licenses between major players typically. So we both can make automobiles with rubber tires, and we both can make a buck. But you want to have a bargaining chip in that mix, right? You want to have some feature that they want, right? And that often is the bargain that is struck between entrepreneurs and large companies. They really want what you got, but you got a patent on it so they can't steal it, right? So they just buy you, right? And you're like, great, that was my exit strategy anyway. I didn't want to run a real company. That sounds like a lot of work. So there's some things that will prevent you from getting a patent. Is if you're offering it for sale, you only have 1 year from it being publicly known or being offered for sale to file your patent. So who knows if it's worth it after a year? And that's the problem that I get, is it's really speculatively. You have to spend speculatively on your patent rights. Because what you want to do is you want to get out in the marketplace and see if you're making money, and then you'll pay for the patents, right? Well, it doesn't work that way. Question?
How did the change to first to file system instead of first to admit system impact that 1 year?
Yeah, so it didn't change the 1 year, but here's the deal. So some people call it a first to, we've gone to what it was to a first to file system. So some people call it a first to publish system. So if I can show that you took the idea from me because it was published, I can still file within that 1 year grace period. But the sucky thing is there's no grace period overseas. So if you plan to pursue patent rights overseas, you really got to file before anybody knows about it. So it's kind of always been a race to the patent office. But today, if it's not publicly out there by anyone and you beat this person by 4 hours, you will be the inventor of it. And it doesn't matter if that person was much more worthy of it or whatever. So Elijah Gray filed his patent on the telephone 4 hours before Alexander Graham Bell, right? Under today's rules, it used to be the first to invent, and Bell was able to show that he invented first. But under today's rules, it would have been the Gray phone company or something, I don't know. But he would have been the winner there. He would have been, under today's rules, the first to the patent office. He got there 4 hours before Bell. He would have been the inventor of the telephone.
So doesn't that encourage sloppy patent applications because you want to race to get it in even if you're not fully done with the process?
Yeah, so the comment is doesn't that require haste? You say sloppy, I say haste. But if you think about what the whole policy behind the patent system is you give me your best ideas and you give them to me quickly. Because there's time on these, right? 18 months. But what if you waited a year and then it was the 18 months? So I think
the quickly is new. I think that's your point.
the quickly is new, but I like it because I think it helps that bargain. It helps me get the brightest ideas from people. You can't sit on it for a few years because this isn't a hot area. You're the only one developing in this. So one thing that happened in the industrial age, the pace of innovation was very slow because I could live my whole lifetime with that factory that I owned out in the woods. Employees never went and worked somebody else. They tended to get chewed up by the machines. They didn't live that long in the day, right? So I could have a model that lasted forever, right? But as we sat there and said, wait a minute, no, tell us about your ideas and we'll let you make big money for a short period of time, the pace of innovation really accelerated tremendously. Huge innovation. And everybody forgets about that. They're like, well, we'll get rid of the patent system. I'm going back out to the woods, right? And I have clients that are literally doing that. They're saying, we're going to lock this down. People are going to be signing agreements. Certain states are making it easier to enforce non-competes. That's the old model, and it was a bad, bad thing. We're living out in the forest.
If, like you're talking about, if you hastily go and patent an idea, within that 18 months, you have time to improve it, correct? Or do you have to repatent the improvements?
Yeah, so if you're hastily doing it, the question is whether in that 18 months you can go and file improvements, or you can have improvements. You only get what's on the document. So whatever you filed hastily, what my clients will do typically is they'll follow it up with additional stuff. And within a year, people will typically file a provisional patent, which is really a placeholder. It goes away after a year. They'll file that provisional patent, and then they'll think it through for that year period, and they'll file a real patent. They call it, rather, they call it a non-provisional patent. But I think of it as a real patent. It's the thing that'll get examined. Yeah, and then they'll improve upon that. And really, it's best to do it in that 18-month period. Because after that 18-month period, sometimes your own stuff can be held against you because of that 1-year rule. So in an 18-month period, you have time to file improvements very liberally, and there are no issues. But once that 18-month period is out, you're going to have other people trying to stand on your shoulders. So the person that sees Edison's bulb after 18 months would then be able to think about their evacuated bulb invention. But if it wasn't published, they really wouldn't be thinking about that, because prior to Edison coming up with that innovation, light bulbs weren't viable. It was just kind of a carnival act. So, actually going to blow through some of these examples. So, just based on time. So, you can almost patent anything. So I did this for a client. This was some of the stuff that they did. All these sorts of things you can get a patent on. And really, you should presume that any sort of problem that you solve can perhaps be patented, is the position you should take. And then talk to your patent attorney based on that premise. But really, anytime you solve a problem, especially if it's a big problem, you ought to be able to get a patent in my mind. And most of the time you can. So real quickly, I'm going to roll through this. It's kind of just a standard workflow of what you might do, some of the timing issues. So up here, you kind of read this right to left and go down, kind of like you would read a book. And up on top is what the company does. And on bottom is what I say you should do. So you move into a new product area. You have this idea, right? You might do a patent landscape study to see what's out there, right? You came up with this new thing, but maybe somebody filed a patent on it 10 years ago and you just haven't seen the product in the marketplace. Or you might find that somebody has a huge amount of patents in that area, and if you try and innovate in that area, you're just going to get squashed by their overwhelming portfolio. Then you kind of invent the thing that you're going to do, and that specific thing, you might do a clearance study to see if you can do that specific thing. Again, looking back at what other people are doing, and it would confirm that what you're doing is actually novel. And then, you got to really figure out what the design is. So at this point, you're just kind of thinking about it, kind of figuring it out. It's kind of in the hasty period. But once you start beginning the design or have the idea even, you can consider filing patents. And it might be hasty to do it at that point, but we can follow up later. At some point, you're going to pick up a product name. File on the domain, right? If you ever do a press release with a name in it that you haven't bought up the domain name, you'll be buying it from a cyber squatter. There are people that's their business model. And in fact, what I would say even is as you're picking your name, use that as a cheap and dirty trademark search. As if you've got a name that you can get a nice short domain name for, and it doesn't have silly things like a dash in it or an I in front of it. It's the shortest kind of incarnation of what you want to go after as your brand. If you can get that, you're probably not going to have any trademark issues. It's a real cheap and dirty way to back your way into a very good strategy. Because if it is something somebody else was using, they would have filed a trademark or a domain name on it, or cyber squatter would have. So what I tell people is start playing around with it and buy them as you're thinking about them. Because if you search it, sometimes the registrars themselves will put a hold on it, and then mysteriously it'll be gone the next day, and you can buy it from auction from one of these domain registrars. Some of them are corrupt. So sit there and get your 10 domain names that you like and think about it from that perspective. You might do some trademark searches to see, because there's old Ralphie with his little market there, and you planned on rolling out worldwide with this brand. At some point, you're going to have to interact with people somehow. Maybe an investor, maybe an vendor, or something like that. That's where you go and use these non-disclosure agreements. We maybe haven't filed patents. Maybe we did initially, but we haven't on our latest stuff. So you get these people to sign a non-disclosure agreement, which keeps things, it stops that 1-year window from starting, and it keeps things in the realm of trade secret, right? So it locks that stuff up. And then you might also consider filing a patent prior to disclosure. Because what if you talk to this person and then they go file the patent? That would be pretty unethical, but what they might do is they hear your solution and it gets them thinking about something else. So they come out with the patent on the evacuated light bulb, because they're like, wait a minute, this light bulb thing is going to take off. Edison has something here, right? So before you go and talk to that person on how to manufacture the glass and would come up with the evacuated light bulb, you file on your light bulb, right? Especially now with the race to the patent office. At some point, you're going to start marketing this thing. File on your trademark application. You already have your domain name there. People really can't rip off your name until they hear about it. So that's kind of the thing to think about it. At some point, you're finalizing your design. You might file more patents that are less speculative at that point, right? You have the actual design. And then you're going to sell your product at some point. Well, you're going to have the software then accessible to people, the manuals then accessible to people. You think about filing your copyrights at that point. And then lo and behold, you make money, right? Dollar sign, right? You want to start policing infringement, right? Are people ripping this off? Are people coming out with similar products? You might come talk to the other half of our Denver office, which is the litigators, the people that enforce your patents. And then, you kind of improve your product, you file patents on the improvement, maybe copyright on the derivative, you make even more money, and you repeat. And that's what business is about, right? Every business has that same, or some slight variation on that. So I'm not going to go through this in the interest of time, but I will say that 4 months out of their IPO, Facebook got sued by Yahoo and had 50 patents. Within about 6 weeks, they were able to amass a patent portfolio about the size of Yahoo's, and they went public, presumably without the worry of patent infringement being successful, the patent infringement suit being successful, and the lawsuit settled there very quickly thereafterward. But there's lots of people that will, especially as you get notoriety as a company and are successful, and certainly IPO, it's very common to have patent lawsuits come in at that point. Question? Yeah, so the question was, is that jobs have a similar story? I'm not familiar with that one, but it's a very common story. I'm Yahoo, Facebook is an ankle biter, right? And Yahoo had done this several times. When Google went public, one of the biggest shareholders in Google was Yahoo, because they had bought Overture. Overture had a lawsuit going against Google, and they settled it with shares in the company. And I think Yahoo dusted off that playbook. And had they done that a year earlier, so to buy up all these patents, is $1.2 billion. Well, what pre-IPO company can write a check for $1.2 billion? If you find them, they'd be a good client of mine, send my way. But no one can do that, right? Except in this wacky world that they found themselves in, where there was so many people that had money. So they were able to solve it, but what would have normally happened, like even if they had gone after Facebook a year earlier, what it would have been is you would have heard about Yahoo buying Facebook. They buy up all these companies. They all wither on the vine and die. But that would have been the story. So Yahoo had a good strategy. It was just a year late. Question? Yeah, so so the comment is with Dyson. There's a lot of competitors out in the marketplace today. Who buys Dyson vacuums? I love them. But I'm kind of a geek, right? So today, maybe it doesn't matter. I don't want to be known as the guy buying that cheap technology. When I grew up as a kid, I grew up very modestly. I always had the cheap stuff. I wore the tough skins. I couldn't buy the nice pants, whatever, right? We didn't have Levi's. We had Lee jeans. Today, I buy Levi's, right? People love brands. So at some point, typically, patents are a rubric to sell yourself as a tech company, to be known as cutting edge, and that becomes part of your brand. So I watched Dyson. I almost bought that silly thing that cleans out your gutters, right? I've never even cleaned out my gutters. I want it. The little robot cleans out your gutters. I love the thing, right? I mean, that's what happens, is often that becomes part of your brand. It's the way that you differentiate yourself. It's the way that you build out your trademark, because trademarks are worth more than patents. But that's your entree into the market, right? Is you've got to be different. You've got to protect those differences as long as you can, so that you can separate yourself from the crowd so people recognize your product. So that was a success story. There's this food fight in the cell phone space. I won't go through it, but I will tell you that just 7 years ago, the iPhone was introduced. And when it was introduced, those were the companies out there, right? None of those products are around today. Windows Phone, Windows has something else, but it's not the same code base. Symbian operating system gone, Nokia gone, Palm gone, BlackBerry gone. If I had told you 7 years ago that that would be the case, you would call me crazy, right? And who knows where this ends up? $20 billion has been spent on that fight. A lot of it going into my industry, which has been nice. But I'm going to get the hook here soon. I have these slides. Oh, there we go. I have these slides over here. It has the 7 gotchas that I was supposed to get to. But we've kind of gone through them in a backward sort of way. Those timing issues. File on your domain name before you roll out with your brand name. When you're talking to people, use NDAs. Another little quirk that happens in the area of patents is that the inventor initially owns the idea. So especially in the formation phase, you may have people rattling around, you don't have your corporation set up. You may have an inventor that ends up owning their idea because it was never assigned to the enterprise. The first time you get money investment, they're going to look at that and make sure that the actual company owns the inventions and not the founders and such. But sometimes at that point, it's hard to get a founder to sign something, and they know they have bargaining chips. Especially when you're working on software with temp workers or consultants or something like that. By default, their copyright is owned by themselves, and you just get a right to use it. So you go out to sell the product, or maybe you want to put it in the cloud and it was originally to sell it. You got to come back knocking on the consultant's door and say, hey, I need this copyright assignment. And as nice as that person was when they were working in your building, helping you out, they got dollar signs in their eyes. That's a lottery moment for them. And they're probably going to hold you up for some cash. Bar dates, everybody wants to talk about their ideas, right? Well, you're giving up your patent rights, and with it being a race to the patent office, I think, contrary to Dave's question, you've got to file speculatively very early in the process. And you've got to, when you're just thinking this stuff through, especially if it's in a hot area, you've got to race down to the patent office and get that on file. And there are ways to do it inexpensively, and some of the prices are in there. One thing to note is in those prices, I'm quoting all in. A lot of people tell you it's so much to write a patent application. What you care about is how much it's going to cost you after it's been argued and you paid your government fees. So people will tell you maybe $10,000 to file your patent. Well, that'll tell you it's $20,000 to $40,000 to get completed with the process, right? So be thinking of that as you're kind of setting up what you need in funding and where you want to set your priorities. Thanks.
All right, let's give Tom a big round of applause.